Okay, hi again. Attorney Steve Vondran here, the copyright and software lawyer. We are talking in this PowerPoint about software audit basics. This is understanding the Autodesk software audit. Okay, so let's get going. Our law office is Stephen C. Vondran. We are licensed practice law in California and Arizona. The copyright cases are federal. We take these across the country. So no matter where you're at, give us a call. We're happy to give you a free initial consultation, walk you through it, pick out a defense, and talk about some of the strategies we may employ. Okay, so this PowerPoint is basic legal information. It's a basic overview of what you can expect if your company's dealing with a software audit from Autodesk. Okay, understanding these software audits, Autodesk is obviously one of the most highly used software programs for architects, engineers, construction companies, manufacturers, graphic designers. So it is a very popular software company. They have hundreds, I think, probably approaching 100 products, if not more than 100 products. So they have all kinds of products, a very large software company. In the old days, many of the products that they created were basically created on a traditional CD software disk, the one that you're familiar with, where it would come in a case with a serial number and you would install it on your computers. And sometimes you would install it on other computers or backup computers. So that was kind of the old days. Nowadays, and by the way, these CD disks, as you notice here, these things can get uploaded to your hard drive and then shared on some of these file sharing sites like BitTorrent and other pirated software sites and things like that. So one of the issues was just making these software accessible to all these other users across the internet. And we've had other cases in copyright law where the software companies or the owner of certain media, digital media, would embed a code, and that code would follow the software around the internet, and whoever was downloading that and sharing that, they could potentially receive either a cease and desist letter or a demand for money. So you have to be very careful when you're using file sharing sites. That's kind of another topic. We do have a video on BitTorrent. If you want to Google Vondran BitTorrent, you'll find some more information on that. But Autodesk does police, oops, I have a typo there, policies its software, but it polices its software. And that means they are out looking for infringers. They are out receiving piracy tips, and they will actively pursue your company if they believe that you have unlicensed software. Now, we're talking as few as one copy. You can expect to get an Autodesk audit letter just for even such low amounts. So again, there's various ways they track you, informants. I do believe there is some monitoring. This is my opinion. I do believe there is some internet monitoring going on, and I do believe there is some informants that are providing information. Okay. Any unauthorized use or copying, that means any can trigger an audit letter, so you need to be aware of that. And in our practice, many smaller to mid-sized firms are a lot of the firms that we deal with, the smaller engineering companies, the architects, graphic designers, so forth and so on. So you don't have to be a large company. They're not only going after the super large, but we've handled a lot of cases with smaller to mid-sized firms. Okay, what is an Autodesk software audit? In basics, the basics of this is it is voluntary. They will tell you you do not have to comply. If you don't want to, don't worry. However, we may sue you. You may end up in a federal copyright court case, and that could be an issue for your company. If that's an issue for you, you may want to participate in the audit. So that's a lot of times when we get the calls is the client will have received a letter from Autodesk asking them to submit, but also threatening with $150,000 copyright damage. And this is for different types of software publishers. We deal with Microsoft, Autodesk, BSA, that's the Business Software Alliance, and the SIIA and their publishers. So it could be a lot of different types of companies that send you a letter, but bear in mind, oftentimes they are threatening you with $150,000 infringement for willful copyright infringement. So these are very serious, And we say sometimes these are an unfortunate part of doing business, and sometimes these audits are the cost of doing business. We do a lot of property management audits as well. And so we tell people these are similar to a property management audit or an IRS audit. It's going to be something that, is going to not necessarily be fun to deal with. And that's why a lot of firms will hire us and say, please take this off our backs, help us guide us through this. And so that's what we do. Again, not a lot of fun to deal with, but as most of our clients, if not all, you can survive. You will survive. We will get you through this with the least amount of damages as we possibly can. So here's just a quick overview: step 1, step 2, step 3. Obviously reviewing the letter, seeing what they're accusing you of. That's important. Assessing the risk, coming up with a realistic model of what you think your software infringement damages are going to be. Is it going to be, $5,000, you pay a fee, license a couple pieces of software, or are we looking at $500,000 up to $5 million, $10 million? So we have to make that crucial assessment. What do we think we're dealing with here? And that's where I have step 2 is basically these are the things you want to contact your copyright lawyer. You want to discuss these issues. You want to basically lawyer up before you just pick up the phone and start calling the software company. We have had clients do that. It never works out well from what we've experienced. They call and they say, I tried to work it out. The attorney on the other side, one of their intellectual property lawyers, seemed very nice, really willing to work with us. And then, we told them we're missing 10 copies, and now they want hundreds of thousands of dollars. So it's never wise to go in and start giving them the information that they're going to want to use against you. And you are dealing with skilled attorneys. So this is where Rule 408, Step 2, Rule 408 is very important, getting these communications with the other party, getting them protected to the extent you can with a confidential settlement communications. Very, very important. And a lot of attorneys that don't know what they're doing get into this and they don't quite understand. The Rule 408, that's a rule of evidence that comes under the federal copyright laws, and those are the laws that apply in federal court. So you try to limit and make your communications as confidential as possible. Step 3, limiting the scope. This is also a time when we try to, if you're dealing, for example, with Business Software Alliance, you would try to limit the scope down to 1 or 2 pieces of software, say Microsoft and Adobe. But in Autodesk has quite a few products, and so one of the things we would try to do is find out what the issue is. Which product are we dealing with that you have the issue with, and we would like to try to limit the scope. Also, step 3, negotiate and settle. Those are actually 2 different things, but I ran out of space there, so I put it in. Negotiate and settle. This is where there really is no substitute for experience. There really, there are some newer firms coming up that are what I call copycat firms. They see other lawyers in this area and they say, well, I can probably do that too. It looks pretty easy. I've watched all Attorney Steve's PowerPoints and, it looks pretty easy. I can do it. Let me just tell you, there's no substitute for experience. Having been through the battle with many, many different intellectual property law firms on a wide variety of software products, there is no substitute. And we can help you. Our goal really is to justify our fees by negotiating down the amount that you're going to pay, negotiating that down to a point where we basically have covered our fees, which is designed to give you the lowest flat rate fees in the industry and allow you to settle your case. In other words, we earn our peanuts, as we like to say. So that's basic software audit. Now let's go over to just a little basic on copyright law. Some people go, I don't understand the copyrights. What is this and how does it work? Okay. Well, basically, as you probably know, most people know movies. And when you go watch a movie, it's copyrighted, or a book, it's copyrighted. You see a copyright symbol on there. You don't actually have to have a copyright symbol for something to be copyrighted. But in most cases, with the software that you're going to be dealing with, Autodesk is going to be copywriting all of their software. They put substantial amounts of investment and time in creating these products, these tools. And these products are going to get registered with the United States Copyright Office. That's going to give them federal registration and the benefits of federal registration, one of which is the exclusive right to reproduce and copy, distribute. And if anybody, any company is violating those rights or violating the terms of a licensing agreement that define those rights, that party will be deemed to be in infringement of the copyright. And so this is a lot of what's going on right now in the area of copyright law. You have so many different creative works out there in the internet, books, pictures, films, jingles, lyrics, songs, software, mobile apps, all kinds of things. Everything is being copyrighted. So when things are being infringed, that's when you're going to get these companies taking a closer look at you and sending these letters. So to me, there is a trend in getting these copyright demand letters, these audit letters from companies like Autodesk and so forth and so on. Infringement penalties: when you have copyrights that are infringed or deemed to be infringing, you are looking at $750. Statutory damages on up to $30,000. Let me say that again, $30,000 per infringing use. So, this is these can be very litigious areas. I just saw a lady the other day was looking at paying about $70,000 for having some frames that were infringing, some picture frames, infringing another person's picture frame. So it's really it's really amazing, some of the things that you see. But you have to take these cases very serious, because if a court case is filed, the damages can go extremely high. If you have 10 copies of infringing software, pieces of AutoCAD, that's $300,000 plus. You're likely looking at paying attorney fees for that kind of infringement. Now, as I note in the second bullet point, it gets worse from there. If you happen to be committing what's known as willful copyright infringement, we'll talk about that in a second, that can be up to $150,000 per copyrighted work. And again, this is normally what you're going to see cited in the letter, because in all essence, they're accusing you in not so many words, kind of by innuendo actually, if you read the letter, that somehow you are potentially engaged in willful copyright infringement. So it's really important to take this letter serious, the audit letter, not to throw it away and not to just say, well, I'm going to ignore it. Lots of times we've seen if you ignore it, there's going to be a second letter or a third letter, and ultimately lawsuits can be filed. And so again, I think it's an important thing for most people. If you get a letter, call us. We can take a look at the letter. We can see what you're dealing with, and we can give you some general strategies so you can understand your software rights and you can create a plan of action. Again, down here, I will just note here, social media reputational damage can be significant. Okay, one of the software providers that we deal with, the software publishers, they will actually try to make you buy out your confidentiality. In other words, they'll say, does your client want this to be confidential? And I say, well, naturally, of course they want it to be confidential. They say, okay, well, that's going to be X amount of dollars, $5,000 or $10,000. So again, these are other items that can pop up when you're dealing with aggressive intellectual property counsel from these software publishers. But if you end up on the internet, people start talking about your company, sharing a press release that may be posted on one of their websites. That may be good for them. It shows how well they police their software, but it's never good for a corporation to have that stigma of being a software pirate or using unlicensed software, that sort of thing. So it's very important. There is very important, significant ramifications to be thinking of. Again, software is subject to end user license agreements. Every software program comes with a licensing agreement. Corporations must follow those agreements and certainly cannot reproduce and sell. You can get into the area of criminal copyright infringement if you're making copies and selling. And we did handle a case where somebody was dealing with that issue, and as I recall, it was several years in jail, so federal prison. So you have to be very careful that you're not exceeding the uses of your licenses, and if you are, that can be, of course, a huge problem. Some companies, especially newer companies, this is another sort of trend that we see. Newer companies that get 4 or 5 copies, maybe it's unlicensed through a file sharing site or a software piracy website. They're getting the software and their mindset seems to be, I'm starting a new company. I can't afford, $4,000 or $5,000, $8,000 a pop. They're here. This is about $40,000 worth of software. Let's just go for it. I mean, we're just a small little company here. Who's ever going to know? And those are really serious cases. Those are some of the most serious cases that we deal with. And again, where you're looking at willful infringement cases like that, they're going to say your company, your client is a software pirate, plain and simple. They are not paying for any software. They don't have any receipts. This is just clear ripoff of our intellectual property. So those are cases where we really have to examine and formulate strategies to combat that. We can't just go, yeah, you're right. So we will talk to you about the different various defenses that we've used over the years, and we can tell you about that. So again, newer companies, be very careful, license your software, properly purchase this, or you could find yourself in big trouble. Again, another one that pops up is companies that are following a merger. Either they were the company that was bought out or they bought out another company trying to grow the business, and nobody is doing software due diligence. Nobody's asking the merging company or the company being acquired, hey, is your software all good? Did we check that? Do you have all your receipts? Do we have all this in check? Sometimes a company may be in the middle of their own software audit, and they may be dealing with the BSA, Business Software Alliance, or Autodesk, SIIA, or some other industry, some other software compliance group, and they're not telling you. They're selling their company because they know they have substantial risk that they're dealing with. So these can raise a whole lot of issues, the warranties and representations that are being made in the sale of the business. So merging companies is another area. I have some suspicions in this area. I'm not going to say that it's toward Autodesk, but I am going to say I do believe sometimes that various software publishers, when they find out that there's mergers, and I believe that information can be obtained when 2 companies merge, that an automatic letter goes out asking for a voluntary self-audit. So if you're involved in that situation, call us, let us take a close look at it, because this is what we get into when we say, is there probable cause evidence to justify this audit? Did you sit with the so-called informant? Is there a so-called informant? How did you find out this information? What's going on here? So there's a whole lot of questions that we ask as your counsel to try to get to the bottom of what's actually going on here. Okay. Who conducts the audit for Autodesk? Oftentimes you will find it's a Northern California law firm. I won't name it. You'll know it if you get it. Contact us and we can discuss it, but we have dealt with their attorneys. They have several attorneys that handle the Autodesk cases. We have some theories on who handles what, so forth and so on. But the important point is we do have a strong established history of working these cases out, getting them settled. Sometimes we even end up upgrading the software, getting current versions, so forth and so on. So if you have questions on an Autodesk, make sure to contact us. Our website again is softwareauditlawyers.com, and we have a ton of information there. So we'll talk about that. Again, do not rush to call and explain. Some people think that this just fixes their problems. I'm going to call in. I'm going to be a nice person. I'm going to tell them exactly. I'm going to be honest. And again, honesty is a great policy, of course, but in the world of copyright infringement, that honesty can turn into willful infringement, and willful infringement can turn into significant monetary damages. One of the new trends with Autodesk, they are moving more toward an ASP, application service provider, what we call software for rent subscription models. So things will be subscribed to online. So there may be less disks floating around in the world, but they are still out there. And again, their attorneys are skilled IP lawyers, and so they know what they're doing in this area. What does Autodesk want? Submit to self-audits of your laptop, servers, networks, computers. They want to know your number of installs, what computers it's on, what your serial numbers are. They want your proofs. They want your proofs of purchase, showing that you purchased the software from authorized resellers and vendors, that you have legitimate evidence of ownership, and paying fair market value for things, not some bootleg copy that you paid $50 for. We had one company that paid, I think, $23 for a $4,200 piece of software. We said, that's going to be a hard sell, but so forth and so on. So here's a list of some of the AutoCAD products. You can see this is not all. They have a huge list of different types of software that they have, but the AutoCAD 360 Pro, AutoCAD Architecture 2016, AutoCAD Civil 3D, Design Suite Premium is a popular one, AutoCAD Electrical, AutoCAD Mechanical, so forth and so on. Revit, that pops up from time to time, AutoCAD Revit. So there's a lot of different softwares. They want to know that you're using this in compliance. Again, how did Autodesk find out about our unauthorized software use in installations? Oftentimes it's informants. If you don't know much about this area, there are rewards being offered, and these informants are promised that their identity will remain a secret. Now that can present an issue sometimes where the informant is stealing corporate trade secrets, or violating exit agreements or severance agreements, violating company policy, or just outright engaged in acts of sabotage. We have had ex-employees that installed the software and then go on to claim the whistleblower status and try to collect a fee. So one of the areas where we get involved in is fighting that, is trying to expose who the informant is and whether they spoke with them. Is there any veracity to this? Do you have any real legitimate reason for sending us a legal demand letter? A lot of clients say this seems like extortion. We've also had clients that don't have any software of Autodesk, and they say, I don't even know what they're talking about. Why am I even getting this letter? So we do get some cases closed out where there's nothing to it. So that's another area that we do talk about with our clients. So you have current employees, ex-employees. We've had cases where the current employee, they say, I know it's a current employee. And I say, well, don't go firing anybody just yet. Let's just, let's talk this through, let's get this worked out, and then we can figure it out from there. So there are some sort of HR, human resource components to some of these cases that do pop up, and we can help you handle that. Contractors, we've had just contractors come out. I've had people that appear to be career informants that appear to be, just coming in, installing software and reporting piracy. So that is something that has to be looked at. There is some information out on the internet also about the potential that software contractors and authorized resellers, vendors, people that are coming into the environment of the company, taking a look around at its internal networks and saying, wow, looks like there's some things short here, and that being reported back to Autodesk. So again, it's a wide variety of things when it comes to informants. It could be a whole lot of things. Bear in mind they try to keep that a secret at all costs. You can check out their website. If you put report piracy, you can see the various entities and organizations, these trade associations that will offer rewards. So it's no secret. You can find it and you can go through their FAQs. Usually it says everything's going to be confidential. So that is one way, the informants, and again, these illegal downloads, P2P file sharing, that's peer-to-peer, BitTorrent, and basically pirated sites. Sometimes we'll get a audit report that has 696969, something along those lines, and we'll say, yep, that was downloaded illegally. That's pretty obvious, and so Autodesk would get their hands on that, and of course you would have a big problem. Those are usually actually our biggest problem cases because it's usually complete 100% software piracy. So we have to deal with that appropriately and raise appropriate defenses. Another way, crash reports. Sometimes you'll have software that'll crash and it will send a report to the company. If the company's matching that up with the licensing and the registration and those two aren't matching, that can trigger a letter. So those are some of the main ways that Autodesk finds out about unauthorized uses. What should you do when your company receives a software audit letter from Autodesk? Again, you can handle these yourself. I would say this is a big risk if you've never done this sort of work before. I think you can really seriously cripple the company, the officers, directors. You can really find yourself in some hot water if you're not careful. We offer the lowest flat rate fees in the industry. We will not be beat on price, service, or quality. And so, like I said, we believe that we make this sort of a no-brainer for you to hire legal counsel and get this done. We do not recommend that you ignore it. Why? Because you could end up in a federal copyright lawsuit, and then the fees and your cost to defend a copyright lawsuit, of course, are going to go through the roof. So some of the estimates on what does it cost for a copyright infringement lawsuit, $50,000, $100,000, $150,000. So you don't really want to find yourself in that area calling an attorney saying, hey, I just got served summons and complaint. That's when it really is going to get costly. So at any rate, we can help you assess your legal exposure, your monetary damages, injury to your reputation, officer and director liability. We can send in a representation letter. Normally, we can seek extended time to respond to these letters, which is also usually important for a lot of companies. We can seek the 408 confidentiality agreement. We can request the probable cause evidence, the identity of the informant. We can work on that angle. You're not always going to get that information. Of course, they're guarding it, but sometimes it's an important leverage point that needs to be pushed. We can seek to limit the scope of the audit. We can help with auditing and reporting, gathering the proof, serial number, and version numbers. That's usually done on the client's end, but we can help review and discuss that. One question that comes up is, should I destroy or delete the infringing software? The letter you receive from Autodesk will normally tell you not to do that. They will tell you not to buy new software, and basically to treat this as a litigation hold. In other words, you're under investigation, somebody believes there's probable evidence of copyright infringement, and they ask you to preserve all that and essentially treat it as a litigation hold letter. So there may be times when a company does want to buy new software. Those are things that we can talk about. Again, it's really fact intensive, specific to your organization, specific to what's going on with you. That's where you need to give us a call. Again, negotiations, this is key and critical. This is where probably we differ from you, and probably where we differ from a lot of other firms. We do not roll over. We do not just hand over the keys. We do not just say, here's a blank check. A lot of other firms, especially some of the newer firms that are popping up, they may not have the skill and experience to really try to grind out a deal here. And again, as we say, justify our fees and make it worthwhile for you to hire us. Settlement, negotiating the settlement terms. Again, these can be more complex than one might think. Some of these settlement agreements are 10, 15 plus pages, filled with legalese, filled with some traps for people that don't know what's going on. And these terms need to be negotiated and can be negotiated, but those are things that we can help you with. Call us for more information. And post-settlement obligations. Once the settlement is concluded, there could be some other obligations that you have to deal with. So we can help you with all that and take this off your back. What do we have? So the typical penalties, as we had, $750,000 to $30,000, $150,000 for willful copyright infringement. Attorney fees and pursuit fees, yes, they will normally seek an attorney fees and pursuit fees on their end. Those are something that's also negotiable. We can also handle that. Just a note, side note, from like cases like Microsoft, where you have Microsoft Office products, which comes bundled with Word, Excel, Outlook, PowerPoint, Exchange, those kinds of things. If you're dealing with a BSA, Business Software Alliance case, in those cases they could unbundle those and be charging you separate infringement fees for each and every one. So those kinds of unbundling strategies can be pursued by the other parties, and those are something we fight very hard to limit your exposure. Autodesk, AutoCAD, a lot of people say, let's get down to it. What are we really looking at here? Typically, what we're looking at is a 1 to 4 times MSRP, whatever the MSRP is, and that is the fee plus a pursuit fee. And some people will say, well, what if I just go buy it myself? They won't let you do that. They don't want you to do that. So, but typically that's what you're looking at, and obviously where you're dealing with a lot of software, you'd rather be more toward the 1 times than the 4 times. So these are things where we can help you make the arguments. Now let's take a quick look at willful infringement. People say, well, what is that? This is the most important thing. We need to rebut and negate any sense or notion that there was willful infringement. And these are factors which will naturally raise the damages in your case. Again, willful means I don't have any software. I've never bought licenses. I download off the internet because it's cheap and free. I didn't know anything about this. I don't know you have to have a license. This is what we call the bury your head in the sand approach. And again, those are willful. Now, as we note here, willful does not mean malicious. You don't have to have a malicious intent. You don't have to be saying, I'm going to rip this company off, when I'm done with them, they're going to have every last, it's not that. It means knowledge, whether actual or constructive. Now, actual knowledge means you actually know about it. Constructive means you should know, you were on notice. As we put here, constructive notice means you were on notice of the infringement, even though you might not have actually been aware of it. So you could be on notice in a variety of different ways. Alternatively, willfulness is shown where the defendant recklessly disregarded the possibility that its conduct represented infringement. So if you have a reckless disregard, I don't know if we have a license, we have 3 departments and they're all sharing the software, and that's not up to me. They do that, and the IT guy should be overseeing that. It's none of my business. Those kinds of things are probably going to lead you more toward the willful infringement, which is going to lead you toward a higher damage award. Okay, so you have to be careful about that. Anyways, let's move to the next one. Directors and officer liability. This is something that pops up quite frequently with smaller companies. You have 3-4 owners of the companies, and they're all, basically members of an LLC, or they're all officer and directors of a corporation. This is where you can get a lot of pressure from the software lawyers. They're calling you and calling out all the officers and directors, claiming that everyone will be sued, in other words. So, what we have here, we have a case, the Atlanta Recording Corp case versus Chin Lang Chan. Court noted a person is liable for copyright infringement by another. This is what we call vicarious liability. Vicarious liability. If the person has a financial interest and the right and ability to supervise the infringing activity, whether or not the person knew of the infringement. Okay, so that is your basic definition. If you had a financial interest, in other words, you've got people using this software, it's making you money, you have a financial interest, you had the ability to supervise what was going on, and you should supervise. That's where we talk about policies and procedures and whatnot. That can lead to director and officer liability. It's a whole nother topic. We have more information on this at softwareauditlawyers.com. That's softwareauditlawyers.com. And director and officer tips, things that we're looking at. Were you aware of the unauthorized copyright use? Were you aware of any illegal downloading or sharing of software? Do you have corporate policies and procedures? We can help you draft those if you don't have them. Does your company implement SAM, safeguards against infringement, SAM being software asset management principles? Are you doing things to help protect against infringement? Documents, are there emails, text messages, cell phone messages, anything indicating wrongful conduct? Those are things that can come out in a lawsuit through discovery, and those things can come back and be a smoking gun against you and really nail you against the wall. So again, did the illegal downloads benefit the officer or the director personally? Are there any defenses? Again, defenses, in-depth legal analysis, that's something we look at on a case-by-case basis. Again, know your software rights. When you are facing a BSA, SIIA, Microsoft, or Autodesk audit, it's important to know you have legal rights. There are defenses that can be raised. You need to understand who bears the burden to prove and show the software compliance. Normally that is the person that's using the software needs to show their compliance. And again, while you can handle these cases yourself, we believe our low flat rate industry leader is the best in the business, and we like to make this a no-brainer. And a lot of companies, they hire us after we tell them what we're going to do. We take this off their back. It's a low flat rate fee. There's no hidden attorney fees. We don't charge for paper clips and copies like a lot of law firms do. So again, having experienced software counsel will take the pressure off your company, your officers, directors, IT staff, and allow you to do what you do best, which is run your business. Okay, finally, tips to avoid software shortages and licensing infringement. Obviously, understanding copyright law, taking it serious, educating your employees, self-auditing your company annually is not a bad idea because new software comes into the working environment. You need to know what's going on, not just for Autodesk, but for Microsoft and a host of other products that are covered by BSA. That's Business Software Alliance type companies. And we have a lot of information on Business Software Alliance if you're facing Microsoft audit. For example, Cal licensing shortages is really big right now. Just Google Vondran Microsoft audits and you'll find a lot of information about all that. Again, develop a sound software asset management program. You may want to create a software anti-piracy team documenting your efforts. It's always important to negate any inference that you're ever a willful copyright infringer. Holding semi-annual meetings, taking notes, minutes of the meeting, those kinds of things. Adopting resolutions that are working toward a sound anti-piracy type environment are important. Again, retain all software receipts in a safe place. Your proofs of purchases, things from online stores must be legit. In other words, again, don't pay $20 for a AutoCAD Design Suite Premium 2016. That doesn't look good. Save your receipts, keep them in a safe place. Another one we've had, another typical case was, I don't know if this is typical, but we have seen this, I should say, is somebody on the way out, they're disgruntled and they take all the receipts and they leave and they knew where all the receipts were retained. They take the receipts, so they're gone. It's really hard to reproduce and find all those again. And then they go and report copyright infringement because they're disgruntled or angry at somebody. These ex-employer cases become very, very contentious. So again, these are things that we will help you fight. We understand what you're dealing with. Again, avoid sharing software amongst different departments and divisions, and maintain your merger and acquisition due diligence. And we can help you with that. If you need a firm to come in and help during that merger and acquisition process, we can help you with that. Okay, any other questions? Here's our phone number. You can contact us there. Check out our Avvo rating. We have lots of reviews on our sites. And by the way, before you hire another firm, that you start looking into hiring another firm to handle your software audits, there are, again, lots of new lawyers coming out, lots of copycat lawyers looking for something interesting to do. We put so much information out there that it's very easy for other firms to, emulate what we do. We don't care. We post the information for the public. We want people to be informed about what's going on. That's how we've run our law firm. But check it before you hire another firm. Check them out on Avvo. See what their ranking is. See how many reviews they have. I think we're at 20 or pushing 20. We've got a lot of successful reviews in the legal areas that we have handled. We have a strong history of success in this area. I've got our website there. But make sure and check out the lawyer's website. If you go to some lawyer's website and it looks like some mom and pop makeshift website that was just thrown up, ask yourself if you really want to be working with a firm that doesn't really look legitimate like that. So be careful in who you're hiring. If you have questions, we are here to help. I have my email address on here if you need us. Other than that, I hope this was a helpful overview of Autodesk Audits, and we look forward to helping you in your case. Thanks a lot and have a great day now.